All rise. Judge Vanderbeek Court now in session. Judge, this is case number JVB 1003, Carrera versus Carrera.
Thank you. You all may be seated. Okay, Mr. Carrera?
Yes.
You brought this case before the court. What's going on?
Yes. So I brought this case before you because I'm currently paying for extracurricular activities for our daughter.
Okay.
And it's a little bit more money than I thought it was going to be, so I would like my wife, Sheila, to reimburse me for it.
Okay. So you guys are separated?
Yes.
Okay. What type of extracurricular activities is the child involved?
So our daughter's very big into sports.
Okay.
So she plays soccer, and it's just like the cost of cleats, the cost of like gloves, because she plays goalie. It's just a lot of upkeep for me, and she makes more money than I do, so I kind of want help with it.
The courtroom is tense as Mr. Carrillo steps forward, frustration evident in his voice. He explains that he has been solely covering the costs of his daughter's extracurricular activities, soccer cleats, gloves, tournament fees, and more. With Sheila earning significantly more than he does, he believes it's only fair that she contributes financially. The judge wastes no time, diving straight into the details of their separation and their daughter's activities. Mr. Carrillo emphasizes that while he is fully committed to supporting his child, the mounting expenses are becoming overwhelming. He argues that shared financial responsibility should go beyond basic child support. It should also cover the activities that enrich their daughter's life. With emotions running high and financial fairness on the line, the judge prepares to lay down a ruling that will set clear expectations. The tension in the courtroom is thick. This case is just getting started.
I see here, ma'am, from the tax returns that you make about $100,000 a year.
Yes, ma'am.
Okay. Child support was not previously ordered.
Yes.
Okay. So are you guys in agreement to do that? Or, or you don't want to pay child support? What's going on?
I don't think it's necessary. We split her 50-50. She's at my house just as much. She's with me just as much, if not more.
Your Honor, I would say that's probably an argument for her to pay me. If we're splitting 50-50, I shouldn't have to pay all of it.
That's exactly what I was getting ready to say. So you kind of like told on yourself. So you ready to move forward with the numbers?
Sure.
Okay, well, let's go ahead and get ready with the numbers. So it looks like you make, like I said, $100,000 a year. Do you work overtime, or is that regularly what you make?
No, I work overtime. But
okay. And does that include overtime?
Yes, ma'am. It's a salaried position, so it's just straight out.
Okay.
Mr. Carrillo lays out his case, breaking down the rising costs of his daughter's sports involvement. Cleats, gloves, tournament fees, and more. He argues that with his ex-wife earning $100,000 a year, it's only fair for her to help cover these expenses. The judge presses further, asking about their custody arrangement. Mr. Carrillo reveals that they share custody 50-50, a key detail that strengthens his argument for shared financial responsibility. He highlights that his ex-wife's higher income puts her in a better position to contribute, making it unfair for him to shoulder these costs alone. As the courtroom waits in suspense, the judge prepares to crunch the numbers. With fairness, financial responsibility, and legal precedent on the line, the decision is bound to make waves.
All right. So at $100,000 a year, I have your gross at $10,000 a month. Mm-hmm. Before I continue, who pays health insurance?
We both do.
We both.
Okay, how much do you pay?
$348 or $386.
$386.
Yeah, $386.
Okay.
And I
how
pay
much?
$200.
Okay, and you both plan on maintaining those health insurance policies?
Yes.
Yes, ma'am.
Okay, great. That way, nobody has to reimburse anybody for health insurance, but because you do carry health insurance and you're going to be ordered to pay child support, I can give you credit for the $386.
Okay.
So that brings your net down to $6,988.19. Which, how many children? Just one?
Just one.
Okay, so 20% of that brings your child support obligation to $1,391.64. That should cover any expenses and anything like that, because the child is heavily involved, sounds like, in extracurricular activities, excuse me. Are there any other questions?
Nope.
You don't look happy about this. What's going on?
I just think that it's a bit of an exorbitant amount, but we discussed it in the beginning when the split happened. He agreed, and
Agreed to what amount?
none.
Oh, you're saying child support, but you do understand that as the child gets older and heavily involved in
Yes.
different activities. I wasn't done.
Oh, sorry.
Involved heavily in different activities, you understand that expenses increase.
Yes, ma'am.
Okay, and the amount of child support is based on how much money you make. Child support is based on a simple calculation. So you make $100,000 a year, that's what your child support is. I mean, if you want it to be lower, you chose the profession.
Yeah.
Okay, so if there's nothing further, you all are dismissed.
The judge wastes no time in delivering a calculated and decisive ruling. After factoring in Mr. Carrillo's overtime, she determines that his total income is $100,000 per year. Adjusting for health insurance, his net monthly income is set at $6,988.19. With this, she orders him to pay $1,391.64 per month in child support. She firmly states that this amount should cover extracurricular expenses, considering his daughter's active lifestyle. She also makes it clear that having 50-50 custody does not exempt either parent from financial responsibility. Looking frustrated, Mr. Carrillo argues that the amount is excessive, but the judge shuts him down, reminding him that child support is calculated based on income, not personal preference. Before wrapping up, she leaves a final reminder.
I just want to go over what you all witnessed in the case of Carrera versus Carrera. So they had an existing order where no child support was ordered. Well, under Texas law, when there's been a material and substantial change in circumstance, the court can go in and review the order to determine whether or not child support should be paid. Well, you heard that dad was covering all the expenses for the child to participate in all these different activities. So it warranted mom to be able to help finance those activities for the child. So that's the reason why mom was ordered to pay child support.
In the case of Carrera versus Carrera, the court reviewed an existing order where no child support had previously been required. Under Texas law, when there is a material and substantial change in circumstances, the court can reassess and modify child support. In this case, the father had been covering all extracurricular expenses alone, creating a clear financial imbalance. Since both parents share equal responsibility for their child's well-being, the judge ruled that the mother must contribute financially. As a result, she was ordered to pay child support to help cover these costs. This ruling reinforces the importance of shared financial responsibility and ensures that the child's needs are met fairly. The judge's decision serves as a reminder that this case proves that when circumstances shift, the courts will step in to ensure fairness, whether the parents like it or not. This version keeps the energy high, flow smooth, and engagement strong, while ensuring clarity and professionalism. Let me know if you need any tweaks.